Hello everyone, Atal Mishra this side from Department of Law, Mewari University, and today we are going to discuss about the law of information technology, which is based on the enactment which has been enacted by the Parliament, the Information Technology Act 2000. So first we will discuss the key definition which are given in the act. The first one is computer. What is computer? An electronic device capable of processing data, including all devices connected to the computer network. Then we have the definition of data. What is a data? Data, as we all know, it is an information which is stored in the digital form, and it is processed. It can be transferred with a medium, which is of course a computer system. Again, cybercrime. As we all know about the normal crimes, but this is the cybercrime have got its origin when the society came across the digital system, the creation of digital space, cyberspace. So in that case, any illegal activity involving any computer network or digital data, including hacking, phishing, and data theft, all these things are considered as a cybercrime, and initially these crimes are committed in the digital space. Again, we have the digital signature and electronic signature, using encryption to verify the authenticity of electronic document. Again, we have electronic record. Like electronic record can be anything like data generated, sent, received, or stored in electronic form. Like we often receive an email and WhatsApp messages and PDFs or Word format. All these are considered to be the electronic records. Then we have legal recognition to the electronic record. The reason being the Information Technology Act was enacted because at the era of 2000 we have already witnessed the development in the cyberspace. So country like India wasn't there need to enact any legislation which can regulate, because due to the advancements in technology, there was a legal vacuum how these technology would be regulated. Keeping those things into consideration, this act was enacted, and as per the section 4 of the Information Technology Act, it says the electronic records are legally equivalent to the paper record. Reason being, initially we were relying upon the papers only. Now, due to advancement in technology, the records are now available on the digital form as well. To give them a legal sanctity, to acknowledge them as a legal record, this particular act it sets a precedent for their acknowledgement. Again, we have section 5, digital signatures are legally valid as a signature. Now the thing is, now in spite of putting a physical pen paper signature, we can also sign a document with the help of digital signatures. So it also got a legal recognition. Otherwise, like how we will acknowledge or say that that particular signature is valid or not. Then we have section C, use of electronic records and signature in government documents. So basically the initiative was taken by the government itself. They have adopted these things, and they have started acknowledging the electronic records and signatures. Then section 10 specifies the requirement for the reliability of the electronic record and signatures. Moving further, we have to understand what a digital signature is and what is a electronic signature. So the first digital signature is uses the encryption to provide authenticity and integrity, verified through a digital certificate issued by the certifying authority, legally valid under the Information Technology Act. So we have to have a clear distinction between what initially digital signature is and electronic signature is. For the digital signatures, there is an authority which is called as certifying authority. They generally issue a certificate. That certificate is generally in the form of pen drive they create, and if you want to sign any document digitally, then you have to put that pen drive in your system, and subsequently it will digitally sign that particular document. And then we have electronic signature. Electronic signature is something like anyone can put. Like any electronic method used to verify the identity of the signer, typing a name using stylus must meet a specific requirement to legally recognize. Reason electronic signature can be put, like we can put an signature on pen and paper, and we can sign it, crop it, and put in any document that would be recognized as an electronic signature, right? So we have to have a clarity on these two distinction, what a digital signature is and what is electronic signature. Now the most important thing, cyber criming offenses under the Information Technology Act. So keeping the legal vacuum, and considering the new kind of origin of criminal offenses in the cyber space. These offenses were acknowledged and subsequently incorporated in another act which made punishable in case someone is caught doing the same. The very first one is hacking. That is given under the section 66. It says that unauthorized access to the computer system or to alter, delete or destroy data. So without the permission of the owner, unethically accessing any computer system which you are not authorized to, that thing would be considered as a hacking, and that is punishable under the Information Technology Act. Like example, a hacker breaking into the bank's data bill to alter the financial records. And then we have identity theft, that is defined under section 66C, fraudulently using another person identity or personal information. Like there are so many offenders who create a fake Aadhaar card or any government document or any identity card of any other person, and that is considered as a identity theft. Creating a fake social media profile, also like using someone else's personal data, is also a kind of identity theft. Then we have data theft, illegally downloading, copying, extracting data from the computer system or network, like copying the confidential company data without authorization. So this is also considered as an offense under the Information Technology Act. Then we have phishing, deceiving someone to reveal sensitive information like password by pretending to be a legitimate entity, sending fake emails from a bank asking for the login details. That is a very common practice which has been done by now by the fraudulent people. What they generally do, they create a fake website of government in the name of government, and people who doesn't have that much technical knowledge, they are just put on a trap to disclose all their sensitive personal data to their website, and then that particular data is being used by those fraudulent people to if it is a bank data, they will withdraw your money without your authorization. So these things would be considered as a phishing. Then we have cyber terrorism. Now due to the excessive development in the cyberspace, this terrorism in the cyberspace have also being a major issue in this the current technical word. So we are using computer network or threaten the security, integrity and sovereignty of the nation. Like generally terrorist group are now targeting the countries through their cyberspace. They are threatening to harm the government, or like hijacking the government website or disturb the national security. These all issues are now being prevalent, and keeping these issues into consideration, this Information Technology Act was enacted, and it is now being subsequently reformed as well to incorporate more and more offenses which are now prevalent in our society. Then we have penalties and punishment for the violation of under the Information Technology Act. The very first 43, section 43 imposes the compensation for damage to the computer system without the permission. Like if you are damaging any computer system without their permission to the data of that computer system, you will be penalized under this act. Then we have section 66B, punishment for receiving stolen computer resources, and it can lead you up to the imprisonment of 3 years and a fine. Then we have section 6C, penalty for identity theft. As we have already discussed, when you are creating any social media account or making any government identity on the person, like on while using the data, personal digital personal data of any other person, you would be subject, if you are caught, you will be subjected to 3-year imprisonment and fine. Then we have section 6D, punishment for cheating by personation using computer, up to 3 years. Like there have been cases where like fraudulers have made a video call to the victims, and they have pretended as a government officials, and they have threatened to take any action against them if they are not going to make any certain payments on the lure of the payments. So in these kind of offenses have been considered as a penal offense under the Information Technology Act, and subsequently those people, if you got, the people are penalized. Then we have some notable cybercrime cases in India. The first was NASCOM versus Azesu 2005, a landmark phishing case where fake email was sent pertaining to the NASCOM. The court ruled against the frauder, emphasizing that protection of data and emails. Again, we have Sony Sambandh case, that is 2004 case, the first major case on online data theft. A customer credit card details were stolen and misused by the misuse on Sony website. It led to the awareness about secure and online transaction. Then we have Bazi.com case 2004, an option MMS clip was showed on the auction platform Bazi. The CEO was held liable for hosting objectionable content, and it also highlighted the intermediary liability. Like we will came across this particular term intermediary, that the social media platform, Facebook, WhatsApp, Twitter, all these platforms are considered as an intermediary, and they have a liability. Like as far as Information Technology Act is concerned, it puts an obligation on them not to host any set of data which is harmful for the public. In case they don't take any further initiative to remove that data from their domain, they are subject to they are being held accountable for the act which is being done by an user. Basically they came a safe harbor under the Information Technology Act, which says that if anything has been done by the user in that platform, there won't be any liability of these intermediary, which is Twitter, Facebook and WhatsApp. But the government also had stipulated the guidelines. If you are not complying with the orders of the government, you will lose this safe harbor, and whatever and this compliant means if any grievance is addressed, if any government rise any flag, or you are seeing any obscene activity or any illegal activity perform on your platform, so they have to voluntarily take action and take down those content on their own. If they are not doing performing these duty on a voluntarily basis and on a proactive basis, then they will lose their safe harbor, and whatever the users accountability directly attached to the these intermediary. Then we have data protection and privacy. As we all know, like right to privacy is now the fundamental right under the Indian Constitution, under Article 21 of the Constitution, after Justice K.S. Puttaswamy judgment. So keeping all those things into consideration, the privacy provision have also been incorporated in the Information Technology Act, which says the implication of data breaches, unauthorized access and misuse of personal information, that is section 66E, punishes the violation of privacy through unauthorized capture and transmitting image of the person of the private areas. Reason being, there have been a spike in the cyber cases where illegal illicit capturing of videos and images were going on. Initially the women and children were being targeted, and they were victimized. Keeping these things into consideration, this particular provision have been incorporated in our act. Then we have data breaches. Any unauthorized access, theft or leak of the personal information can result into legal consequences, including compensation for damages to the affected parties. Like unauthorized access to the computer data is stored by the bank or e-commerce platform may result in penalty. Misuse of personal information, like as far as like our personal information is concerned, that carries a value, and that is also considered as a sensitive data. As if it is being misused, then the authority, then the party who is having a personal data, so they had an obligation that data must not be misused. In case they fail to protect our data, then they are subjected to the uh, penalty. Then we have protection of personal data. Sensitive personal data includes financial information, health data, password and biometric. As we all know, like we use digital platform, they have certain login ID, password, biometric, like our iris scan, our thumb scan, our facial scan, and all the health data. So all these things are considered as a sensitive personal data, and that needs to be protected at any cost, and the legal framework we already have. Then we have section 43A of the IT Act that imposes the liability on companies for failing to protect the sensitive personal data. They must implement the reasonable security practices. The reason being, the companies who have the personal sensitive personal data of the citizens or the users, they have an obligation to protect their data from being misused. In case they fail to take reasonable security measures and there is a data breach, then they are subjected to the liability under the Information Technology Act. Then we have rules for the data protection under 2011 guidelines that have already set an obligation on these companies to handle sensitive data very carefully. Then we have amendment impacts of the 2008 amendment, the recent amendments we are talking about. Then strengthening the data protection, 2008 amendment introduced stricter penalties for the data breaches and strengthen the definition of sensitive personal data. So this gives a strict platform to the companies who are involved in handling the personal data. Then we have legal recognition to the electronic contract. Initially what was happening, we were not strengthened to the this electronic contract, but now it has got the legal recognition under the Information Technology Act. Yes, you can make a contract through a digital platform as well, and it would be considered as electronic contract, the contract signed through electronic medium. And it also empowerment of adjudicating officers, enhance the power of investigate, penalize the data breaches, giving more authority to adjudicating officers under the IT Act. Initially there was no authorized authority which can investigate on the breaches, to check whether the compliance are being made by the concerned bodies. So for these this particular amendment strengthened the investigating procedure and also gave some sort of power to the authorities, so that they can have a check and balance on these things. Then there are the emerging issues and challenge in the IT law. The very first is recent cyber attacks. There have been groups who are attacking the servers, the website, the personal informations which is stored with the government or any private entity, and they ask the ransom in the exchange of that particular data breach. They will ask that yes, you should pay this much amount to us, otherwise we will disclose all the sensitive personal information which they have stolen from their websites to the public domain. And we have the security measures. What it says that the company should take all the initiative using the firewalls, encryption and multi-factor authentication, adoption of national cyber security policy to strengthen the country's cyber security infrastructure, encouragement to the cyber hygiene. Reason being that when the country and the citizens are suddenly shifting towards the cyberspace and involvement, their major involvement in the cyberspace, it becomes really prevalent how they are going to protect their personal data, what are the security measures which has to be taken to protect their personal data. That is also an important consideration under this. Then we have social media regulations, how government have to regulate the fake news, as in our latest cyberspace issue is like so much fake news has been circulated to the digital platform. Like we often receive any deceiving or fake messages in our WhatsApp that this is what happened and this is is happening. So many misconception of being created in the mind of the citizens through these platforms while circulating the fake news and information. So platforms are required to remove these fake content within the specified time frame after receiving a valid notice. In case if you find any information that is to be fake or vague in those situations, a notice is being served to the platform if they are not taking any specific initiative in that stipulated time, then they lose the safe harbor, as we have already discussed in a previous slide that the platform or have an immunity from any legal actions upon the actions of their users on their platform. Then we have privacy concern. Regulation mandates the platform to ensure the privacy by limiting data collection and ensuring the data transparency. Then we have intermediary guidelines 2021. Social media intermediary are required to appoint a grievance officer to ensure swift residual and user complaint. And we have content removal thing as well, where a platform must take down objectionable content including hate speech, explicit material and illegal content within the specified time. Like in 2022, major social media platform removed thousands of the posts response to the legal takedown notice. So government or any individual can flag these issues on the platform itself, and platform is required to take further initiative to remove all those contents from the websites. Again, global perspective, we have Budapest Convention on Cybercrime. It is a legal, it is a general understanding with global understanding, we can say, among the countries, which focused upon improving the cooperation between nations for investigating the cybercrime. Then we have in European Union have enacted the General Data Protection Regulations, which set a global standard for data privacy, including India approach to data protection. Again, we have India's alignment with global cyber laws, that there have been several efforts being made to harmonize the Indian cyber laws with the international standard, and we have Information Technology Act, and again we have now also enacted the Digital Personal Data Protection Act as well. India's participation in the international forum like United Nations, groups of government and expert on advancing norms for the responsible state behavior in cyberspace, consideration for the personal data protection now, which is an act and which is in conformity with the GDPR regulations, was very much motivated from the GDPR only. So these kind of initiative must be taken, and these are the global perspective which are now being adopted in our country. Then we have the latest development, ongoing changes, introduction of Data Protection Bill. Now it is an act, Digital Data Protection Act 2023, focusing on the individual's data privacy and consent. Then amendment procedure for the cyber security standard in response to the evolving threats. Then we have expansion of social media guidelines to include more transparent regulation of faster and time response. Reason being, social media have a greater impact on our society, so we have a strict regulation how we are regulating these social media platforms. Then we have latest challenge what is in the digital ecosystem, handling of data breaches and increasing emphasis on data protection. Again, we have the new challenge in the digital platform, that is artificial intelligence and its ethical implications. Again, international effort to address the cross-border cybercrime need to be global cooperation. Reason being, a cybercrime can be committed from a very outside of the country, like it is not just any place a limitation on that. So in those particular situations, if someone sitting in US and committing and can easily commit a crime in India, cyber crime in India, easily commit a cyber. So how they will set an accountability for the person who is not present within the country? It is out of their jurisdiction. So these international efforts are being made so that the convicts cannot evade any kind of accountability for their wrongdoing, despite the fact he is sitting in the US and committing crime in India, and he can also be punished for their wrongdoing. Again, balancing the freedom of expression with the content moderation in the digital platform. Reason being, we have also the concept for freedom of expression and the Article 19 of the Indian Constitution. Article 19 clause 1 subclause A says the freedom of speech and expression. So we that implies on the social media platform as well. So reason being, there should not be any unreasonable restrictions on the on our expression on the digital platform. So there is a balance while allowing the citizens to express their self in the digital platform, and subsequently restraining also from making any hate speech or circulating the fake news through the digital platform. So that's all from my side. Thank you.